Good afternoon and welcome to our seminar on the FCA's business interruption insurance test case. My name is Simon Sloan. I'll be one of your co-presenters together with Jeffrey Guda QC from Essex Court and my colleagues Stephanie Marshall and Emily Wise-Jackson from Field Fisher. Just a brief comment on the running order. Time will be tight because obviously there's a lot to discuss in this important decision. You should have a chat function in your control panel. Please send chats either directly to me privately or open questions to the forum, and we will try and address them either during the presentation or at the end during the question and answer. We have already received a number of questions before we went live, and we already have those, so you won't have to repeat them. Now, the FCA's judgment is an important judgment, and fortunately, whilst in many cases can make the law appear an ass, I think in this instance, Lord Flo and Sir Christopher Butcher have applied common sense to the insurance principles and applied them in what should be a coherent and enforceable manner. Emily Wise-Jackson and Stephanie Marshall will lead us through some of the opening comments, and then Jeffrey Guda will deal with the disease issues and causation. I will then look at the denial of access or prevention of access and implications of the trends, and Emily will close us off with preventative measures and proof issues before question and answer. So let's progress quickly with Emily. Emily, thank you.
Thanks, Simon, and thanks again to all of you for joining us today. So before we dive into our analysis of the judgment, we thought it would be helpful just to do a quick recap of the background to the test case and why the FCA, as the financial regulator, decided to bring the test case in the first place. So it first announced its intention to do so back in May, saying that it wanted to seek to resolve some of the contractual uncertainty that had arisen as to whether business interruption insurance policies in the market were responsive to the events of the COVID-19 pandemic, which obviously has caused an enormous amount of disruption to a large number of businesses in the first part of this year. So before commencing the action, the FCA invited policyholders and also insurers to submit details of business interruption insurance claims that they had or policies that they were selling, and give an indication of what the response they'd had to those claims had been or how they were intending to handle them. And the FCA and its legal team then went through those policies that were submitted to it and identified what they considered to be a representative sample of some of the key arguable issues in relation to coverage of COVID claims. And I think this really underscores the significance of Tuesday's judgment in that already by early May, the FCA had reported that it had been informed of 8,500 claims under BI policies that were likely to be affected by the test case judgment, with a value of around 1.2 billion, and that was only by May. So a number of insurers have policies that include wordings that are within the representative sample, but 8 of those who are the insurers whose names you can see on the screen were asked by the FCA and agreed to participate as defendants in the test action. And the FCA itself took on the role of representative of the interests of policyholders generally. And it entered into a framework agreement with the defendant insurers, which sets out, among other things, the parties' mutual objective of, and I quote, achieving the maximum clarity possible for the maximum number of policyholders, especially, although not solely, small and medium enterprises and their insurers, having regard to the need for expedition and proportionality. So just moving on to the next slide, what the FCA asked the court to do in the test action and what the judgment does is to determine certain issues of principle in relation to the proper interpretation of the policy wordings that were included in the sample. And the court wasn't asked to, and the judgment does not, determine any policyholder's individual claims. So, nor does it purport to address every single issue that might arise in relation to the resolution of a particular policyholder's claim. But the hope is that by addressing some of these key issues that arise in relation to a large number of policies, the judgment can streamline the resolution of those individual claims going forward. I think it's also just worth noting that subject to any successful appeal, the judgment is legally binding as to the interpretation of the specific policy wordings that have been considered, but it'll also provide persuasive authority in relation to how similar policy wordings that weren't necessarily included in the sample itself ought to be interpreted. So I'll just hand you over to Steph now, who's going to introduce that representative sample.
Thank you, Emily. As Emily touched on, the FCA had a big job in selecting a sample of 21 business interruption policy wordings that it believed to be the most representative of the most frequently used policy wordings that were giving rise to this uncertainty in the industry. The policy wordings selected were chosen from over 500 relevant policies from 40 insurers. There'll be many policies out there on the market with similar wordings, and this judgment, as Emily touched on, will be persuasive as to how those are interpreted and treated going forward. So there are three main categories of the clauses that are causing this uncertainty, and they can come down into disease clauses. These ones provide coverage in respect of business interruption in consequence of or following or arising from the occurrence of a notifiable disease within a specified radius of the insured premises. There's the prevention of access category clauses. These have a variety of wordings, but they're looking at effectively where there's cover, where there's been prevention or a hindrance of access to or use of the premises as a consequence of government or local authority action or restriction. And then finally, the third category is hybrid clauses, and these are referring to restrictions imposed on the premises and to the occurrence or manifestation of a notifiable disease. An important thing to note about the FCA test case is how expedited it was. You can see there from when the claim form was filed to when the judgment was handed down that it was a very quick turnaround, and that's largely due to the uncertainty in the industry. And one thing that's worth mentioning as well under this is that this was the first case under the financial markets test scheme to be heard. We'll just flag sort of at the outset that there is the possibility of appeal, but we will discuss that in further detail towards the end of the webinar. And now I'll hand you over to Jeffrey, who will be able to go through the clauses in more detail.
Thank you. If I can turn to the disease clauses, and the bullet points on this slide effectively deal with the various constituents of the type of disease clauses which the court was dealing with. So one had cover for business interruption in consequence of following or arising from as a result of any notifiable disease, or there are various variants of that, within 25 miles or possibly 1 mile of the insured location. So those are the various constituents of the type of disease clauses the court was dealing with. And it's to be noted that COVID-19 became a notifiable disease under the relevant legislation on the 5th of March 2020, which is relevant to these clauses. And the policies which the court was dealing with were policies which were written by these companies, RSA, Argenta, MS Anlin, and QBE. There were 3 QBE policies considered, which we'll come to later. If we can move to the next slide. Now, in relation to these clauses, the central question was, must the presence of COVID-19 in the radius area, let us say within 25 miles of the premises insured, be the proximate cause of the interruption or the interference with the business? The insurers argued that the proximate cause, which they, if I can in passing say, they wrongly identified as being the but-for clause, was the national pandemic and or the government responses to the national rather than any local state of affairs. So the argument was, even if your business was in central London, and even if there were, as at March 23rd, numerous cases of COVID-19, we can assume, within 25 miles of central London. The real cause of your loss was the government government-directed lockdown, which was not determined by the state of affairs in London, but the state of affairs nationwide. That was the type of argument, and of course the argument would have been even stronger if one had a business insured under one of these clauses in an area where there were very few cases of COVID-19 as of, let's say, March the 23rd, let us say somewhere like Cornwall. Now the court disagreed with the insurers. It said the proximate cause of the business interruption was the notifiable disease of which the individual outbreaks form indivisible parts. Alternatively, but the court said less satisfactorily, each of the individual occurrences was a separate but effective cause of the national actions. If we can move to the next slide, please. Now, and what I've got here are two quotes from central passages of the judgments. So in paragraph 102, the court said the court can and should, the clause can and should properly be read as meaning that there is cover for business interruption consequences of a notifiable disease which has occurred, of which there has been at least one instance within the specified radius. So they, from the time of that occurrence. So on the basis of the judgment, even if there was only one case of COVID-19 in the area, the radius area, then there would be coverage. The wording of the clause, in other words, indicates that the essence of the fortuity covered is a notifiable disease which has come near rather than specific local occurrences of the disease. And I think in the interest of time, I won't read the second passage, but it's there if you want to read it. So if we can move on to the next slide, please. Now, the wordings, and I think the crucial factors in the judgment was the wordings did not expressly state that the disease should only occur within the relevant policy area. So it was contemplated, especially since we are dealing with infectious diseases which don't respect boundaries of a 25-mile radius, that those diseases would be capable of widespread dissemination, such as SARS, which was another notifiable disease before COVID-19. And it was therefore contemplated that some of these diseases which had preceded COVID-19 as being infectious diseases would engage a response by national and not just local bodies. And human infectious and contagious diseases, but by their nature, spread in a highly complicated and fluid pattern. And therefore, cases within the relevant policy area are not independent of and a separate cause from cases outside the relevant policy area. And therefore, the court said there were no causation issues if the government response was not solely or even primarily prompted by. If we could move on to the next slide, please. Now, I just want to touch on certain points of terminology because, like any legal issues of construction, the wording really matters. So first was got the question of occurrence of the disease or manifestation of the disease, and occurrence would include asymptomatic sufferers. Manifestation would not. So for a disease to be manifested within an area, either the sufferers have got to have symptoms such as coughing or breathlessness, or diagnosed by a test. but purely asymptomatic sufferers who are not tested and don't show any outward symptoms, the disease would not be manifested. And therefore, there's a very important difference also in the judgments between vicinity as a defined term and vicinity with a small v used in its normal sense, because vicinity was a defined term in RSA's March reliance wording, and that was defined as an area surrounding or adjacent to an insured location in which events that occur within such area was reasonably be expected to have an impact on insured or the insurer's business. And that was widely construed, as you can see in the next bullet point, to actually, in the context of COVID-19, including potentially the whole lot of England and Wales, could be considered to be within the vicinity, capital V, according to that definition. But you must compare that to the small, to the term vicinity with a small v in certain prevention of access wordings, which was held to be a very confined term, confined to the neighborhood of the particular business. And in those type of cases, effectively, there was not coverage because the disease within the vicinity, small v, was not held to be a proximate cause of the loss. So can we please move to the next slide? Now, I want to come to QBE2 and QBE3 because the claims there failed. QBE1, which I'm not going to deal with, was similar to the clauses I've just been considering, and the claim potentially succeeds in QBE1. QBE2, which includes the NDML Nightclub Policy, the wording was slightly different because it says loss resulting from interruption of or interference with the business in consequence of any of the following. And if it had stopped there, then there would not been necessarily a problem. Unfortunately, the policy used the word events, and the word event, or the term event, is a term often used in, for example, aggregation clauses. And in that context, it means that what is being insured are matters occurring at a particular time, in a particular place, and in a particular way. And the court therefore construed the term loss resulting from interruption, interference, business, and consequent any of the following events as being an occurrence of a notifiable disease within a 24-mile radius, and that is it. It didn't allow the much more generous interpretation. It might have permitted without the word event. And then, of course, the court also reinforced its conclusion because of the use of the word incident, which again, it interpreted in a similar way to event. So that is why the claim under QBE2 failed. If we can go to the next slide. And this is what the court said. Emphasis appears to us in this clause not to be on the fact that the disease has occurred within 25 miles, but on the particular occurrences of the disease within the 25 miles. Is the event which is constituted by the occurrences of the disease within the 25-mile radius, which must have caused the business interruption or interferences. If there were occurrences of the disease at different times or different places, these would not constitute the same event. and the clause provides no cover for interruption or interference of the business caused by such distinct events. So the problem is that the national lockdown in those circumstances was not solely caused by the incidence of the disease within the 25-mile radius of the business insured. And they also said a pandemic was not an incident. So if we can move on to the next slide. Then QBE3, the wording was similar to QBE2, but the limit of the radius was 1 mile rather than 25 miles. And that just further reinforced the court's view that the parties had contemplated specific and localized events. So there might be cover, for example, on QBE2 and QBE3 for the type of local lockdown which one had seen in for example, Leicester or some of the other northern towns, or indeed Wales, but not for the national lockdown which was mandated on the 23rd of March. So if we can move on to the next slide. And I know Simon is going to talk about the trends clause and also Orient Express, but the effect of this judgment is that if there is cover, the trends clause really becomes totally irrelevant. And the comparison is being trading without COVID-19 and government restrictions, and trading effectively during that time. And the trends clause is intending simply to put the insured in the same position it would have been had the insured peril not occurred. So where the policyholder has established a loss caused by insured peril, the loss is not going to be limited by the inclusion of any part of the insured peril, the assessment of what the position would have been if the insured peril had not occurred. And insurers, for example, can't say outside the 20-mile radius. You've got to assume a situation where there was no COVID-19 within the 25-mile radius, but there was lots of COVID-19 outside the 25-mile radius, and therefore reduce the amount recoverable because of that hypothetical situation, because the court says that the disease inside the 25-mile radius and outside the 25-mile radius is effectively the same peril, and there's similar reasoning in the prevention of access. So if we can move on to the next slide. And I think that's the next section, which is not mine.
Thank you, Geoffrey. Just before we go on to the prevention of access and the disease coverage that the courts have granted, confirming that pandemics per se are not automatically excluded absent an express exclusion clause, coupled with their decision that the but-for test isn't the appropriate test, do you think those two areas might be key areas that insurers would seek to appeal?
I personally would think that if I were an insurer, I would probably want to attack the way that the court have approached the let's take the 25-mile radius clause. I would probably want to argue that they have been much too generous, and they would have to show that the presence of the disease within the 25-mile radius was a proximate cause of the business interruption. I don't think the difference between the but-for cause and the proximate cause is probably that crucial in the context of this case. But I think if I were an insurer, I'm not saying they would be right, but I would say that, for example, this leads to a situation where somebody whose business is in an area which only had very few cases of COVID-19, let's say parts of Devon and Cornwall, which I think didn't suffer that badly, that business is closed down because of a governmental instruction based upon a national situation. I would want to argue that really that business should not succeed if I were an insurer on the basis that the presence of 19 in approximate. So I can see that being an area insurers might want to look at.
Great, thank you. We'll press on and then we can come back to some of those issues at the end.
Yes, sure.
As Jeffrey's discussed, the disease wordings were one of the areas they looked at. The prevention of access or denial of access wordings was one of the other key areas that they looked at. And policy wordings were taken from Arch Ecclesiastical, a variety of Hiscox, Amlin, RSA, and Zurich. I don't propose in the limited time we have to go through each of those wordings in the clauses for each insurer. But there are a couple of key triggers that are common to all of those where they require interruption or interference due to an action, be that advice, restriction, or the imposition of an order. And then it's either by a government, local authority, the police, or other body. And then the final criteria is due to an emergency likely to endanger life or a danger, an incident, or within a specified vicinity. And those are either collectively combined or stand alone. The court in this context also looked at the possible impact of social distancing and whether that fell within the definition of prevention or hinder. And we'll come on to that in a little while. Next slide, please, Stephanie. On the screen are, and for your benefit only, are a couple of samples of the prevention of access wordings, so that you can have a quick look at those. They are quite, particularly the first one, not convoluted, but process, and they have a number of different elements to them. And as we can see, so does the Hiscox and RSA one. Next slide, please, Steph. Now, I've put together this slide in a table format, which I've tried to make sure it encapsulates as succinctly or as easily digestible as possible, given the likely audience, of the court's financial or final conclusions dealing with these denial of access or prevention of access extensions. With regard to the Arch policy, and the principle runs through for all policies where they have similar language, the court accepted insurers' argument that prevention cannot be mean mere hindrance. It's got to be complete closure of the premises. Now, what complete closure of the premises means will be fact specific. So, unfortunately, you will have to go to the facts of your individual business to look at whether you fall within the prevention, whether it's under Arch or any of the other triggers, if that extension has provided cover. For Arch and also for prevention, while it does require closure of the premises, it doesn't require total closure. And I think the sort of arguments or argument that the court accepted was, if you were a restaurant and you don't provide a takeaway service, you close your restaurant, but then you open up and provide a takeaway service. They said that would be total closure of your restaurant as defined as your business. You're a sit-in restaurant. The business of takeaway is completely different to the sitting in a dining experience, and therefore that would be a slight change in your, so you would, for the effect of your business, have a total closure. But these are all very much fact specific. And then they also said that the prevention needs, under the Arch policy, closure of the premises would either be triggered by the advice of 20th or 23rd March or by the regulations, the legal regulations of 21st and 26th March. And then I've just provided the various categories in the final column, which some of you will be familiar with. Category 1 obviously is pubs, restaurants, cafes, etc., which were closed for the purpose, and therefore they would be captured under the Arch policy, as would Category 2 businesses, leisure, cinemas, theatres, nightclubs, etc. Category 3 wouldn't necessarily, because these were essential shops and businesses that stayed open, so there was no prevention or hindrance. And then non-essential shops in Category 4, which did actually close, even if they weren't legally obliged to close, would also fall within scope of cover, of trigger of cover. So you need to look at your policy quite cleverly. That's unique to the Arch policy. Ecclesiastical is a slightly different and unique policy in the context that, although it provided cover for prevention of access, it had an exclusion clause where the prevention of access didn't bite, where it was caused by government action due to presence of infectious disease. And the court decided, rightly so, I think, didn't determine the exclusion as being an exclusion per se, and therefore to be read narrowly, but they said it delimits cover or delineates the scope of cover, and so it doesn't provide prevention of access where it is due to infectious disease. And so ecclesiastical will have no cover in that extension, and so I haven't gone through the causation and category issues. The various Hiscox 1 and 4 and Amlin 2, although slightly different, they do have a narrower scope of cover, and as Jeffrey mentioned, with regards to the QBE event language, the court said that the reference to an incident within the vicinity of the premises implies a narrower localized cover, although the interruption can be a mere disruption, because it's not, we're not dealing with, so if you have a disruption in a local area, then you'd have cover, and it would include hindrance, not just prevention. So that's good news. The bad news for the policyholders having those covers would be that because it's a narrow cover, scope of cover, there is unlikely to be causation, because you'd need to prove that there was a restriction within your local area, where the court has decided that the national restriction was due to the national pandemic. The situation might change when we get to local lockdown in regions, as we've seen recently in Greater Manchester, Birmingham, Leicester. So it's not, the categories aren't applicable at this stage, but obviously if it goes to appeal, the court then went on to deal with, if they are proven wrong or held to be wrong on appeal, then those categories are likely to be triggered, and I've marked them up there. Again, categories 3 and 5 on the face of it wouldn't necessarily be triggered. Likewise, MS, Amlin and Zurich have similar prevention. So there's a total closure, but again, it's a narrow cover because it references an incident, and like the Hiscox and Amlin policies above, the action of the authority must have a force of law, so it's only going to be triggered by the regulations of 21st, 26th March, not the advices of the PM on the 20th and the 23rd. RSA 2, dealing with those for the same reason as in Hiscox, the causation issue. You've got limited cover, but you're unlikely to be able to prove they were causative of your loss. So those covers are unlikely to bite due to the national lockdown. They may bite in respect of localized lockdowns, that we are experiencing now. RSA 2, the prevention, has prevention and hindrance up to a capped limit. And again, there's no reference to incident here, but there is a reference to an emergency within immediate vicinity of the premises. So again, we have a localized cover, and policyholders, in order to trigger cause, to show cause of loss, would have to prove emergency locally, which will be difficult to do. Likewise, RSA has prevention and hindrance cover, but this one has no local requirement of either an incident or an emergency. So it's the broader scope of cover, similar to that provided in Arch, and the same categories should be triggered. Obviously, all fact specific to businesses' individual claims. And respect of both the social impacting, where you've got hindrance cover broader than just prevention, the court said that the social distancing would be a factor hindering access. Again, though, it would be very much fact specific. Next slide, please, Steph. With regard to the hybrid wordings, now these are a mix of wordings having both the disease cover and a restriction based on the premises due to the disease, and the court has adapted its approach accordingly. In particular, it's Hiscox 1 and 4 and RSA 1 and 4 for reference points. Just looking at the RSA 1 policy, which is the RSA Cottage Shore, which has loss as a result of a closure or restriction placed on the premises as a result of a notifiable human disease manifesting itself at the premises or within the radius of 25 miles. So you can see it's got the disease standard cover, but the interruption is due to the restriction. And the courts have said that that will provide cover, but because it's a restriction, it needs legal force, so will only run from the 21st or the 26th March regulations. Next slide, please, Steph. Now, the trends clause, as Jeffrey's already mentioned, the court held that trends clause has no impact when looking at the scope of coverage. It's only there to deal with the mechanical quantification. And we've set out an example of the trends clause there. This decision of the court is personally, I find very pleasing. I was tangentially involved in the Oriental Express. I drafted up the statement seeking leave to appeal that. I wasn't involved in the underlying arbitration, but I was asked to get involved because we'd had similar success on another BI claim resulting from the Asian tsunami in 2004, impacting on hotel businesses. So the Orient Express has had a lot of criticism over the years, not only from policyholders, but also from loss adjusters, and also from the industry, the insurers themselves, who can see the unfairness sometimes in the fact that the greater the damage to the region, the less likely you are to have, or the greater is going to be the reduction in your claim because of the damage to the region. Now, that the Orient Express decision, next slide, please, Steph. The Orient Express decision has been debunked by the court, and they said both the arbitrator's approach, as confirmed by the court in 2010, based it on a fallacious reasoning that the damage was the insured peril, whereas because in Orient Express the hotel was based in New Orleans and damage was caused not only to the hotel but to the region by a hurricane. Insurers said but for the physical damage to the hotel, nobody would have gone there because New Orleans was still devastated, which effectively takes away any cover. But unfortunately, Oriental Express came out in favor of insurers based on the specific language of the clause that was in the previous slide, where it refers to big D damage. And the court said that was a fallacious approach, both by arbitrators and the judge, proceeding on the basis that what has to be stripped out is not the damage itself, but the insured peril, the damage caused by whatever covered peril caused the damage, because that trends clause is only dealing with circumstances outside the impact of the insured peril, rightly so. And I think this is a key area for policyholders, because even if they had succeeded in getting cover under the disease or one of the prevention of access extensions, if they had lost on Orient Express on the trends application, then a lot of the damages would not have been recovered in any event, because insurers would have said, fine, you might have had a disease manifesting itself within the radius, but when we come to adjust the amount of the loss, all your losses flowed from the national lockdown rather than the manifestation of the disease in your vicinity, and therefore you suffered no loss at all. So it's actually this issue, I think, which is going to be the biggest boon for policyholders, not only in respect to the FCA case, but also in respect of business interruption policies going forward. I wouldn't therefore be surprised if insurers seek to appeal this specific point, although I have a bias in favor of the current findings by the FCA and the judges in this case, so I sincerely hope that they don't succeed if they do appeal. I just want to deal with a couple of consequences of the trends clause in respect of the three clauses that we've looked at. Jeffrey's already dealt with the disease clause specifically, but in respect of the prevention of access clauses generally, where we have the loss of income or trends provisions in the wordings, they don't have reduced scope of cover, as I've already said, and therefore the insured peril is the composite peril involving the three interconnected elements: the prevention or hindrance of access to or use of the premises by any action of the government due to an emergency or an incident or danger to life. So where you have those three triggers, all of those, that composite in peril, all of those come out of the adjustment period process when you're looking at the trends adjustment to reduce down the loss. Likewise, in the hybrid clause, particularly I think in the context of the Hiscox wordings, where it involves public authorities, the court considered that the way the counterfactual must be applied is that the composite involves the inability to use the insured premises due to the restriction imposed by the public authority following the occurrence of a human infectious or contagious disease, and that entire insured composite peril comes out. Next slide, please, Steph. Right. It is now, I think, back to Emily to deal with some important burden of proof and prevalence issues.
Thanks, Simon. Yes, just going to say a few words on this, because as we've seen, certain of the policies that the court considered do require a policyholder, in order to make its claim, to demonstrate the occurrence or the manifestation, whatever the term is that's used in the particular policy, of COVID-19 within a particular geographical area in which the insured premises is located. And I think the key takeaway on this is that the court has not made any actual factual findings as to the occurrence of COVID-19 at a particular place or on a particular date. And those issues are therefore left to be determined on a case-by-case basis. And it's also important to note that the particular factual matters, as has been apparent, I think, from the discussion that Jeffrey and Simon have just had going through those policy wordings, what factual matters are to be proved in each case will be different depending on the policy wording and also the time and location that the claim relates to might impact what evidence is available in order to do that. The other just introductory point on that is that the court did make clear that the burden of proving those facts remains on the insured party seeking to make its claim. It declined the FCA's invitation to introduce any sort of rebuttable presumption that if an insured party could point to particular types of evidence as to the prevalence of COVID-19, then there would be a rebuttable presumption that the burden of proof in respect of those facts was met. So just moving to the next slide, I do want to highlight 3 points that the court has made that I think will be quite relevant to note for any parties who are dealing with issues of proof on business interruption insurance claims going forward. The first is that the defendant insurers accepted that the types of evidence that the FCA had identified in its pleadings in the proceedings, which are set out on the slide there, could in principle discharge a policyholder's burden of proof, as could other types of reliable statistical evidence. And the court noted that the insurers had not suggested that absolute precision would be required in order for an insured party to make good its claim, which I think is encouraging from the perspective of a policyholder seeking to do that. The second observation I just want to highlight is that there were a couple of issues in terms of the inferences to be drawn from that evidence that remained in dispute between the FCA and the defendant insurers, but which the court did not consider itself to be in a position to resolve in this judgment, because it hadn't had the evidence before it that it felt that it would need to do so. And the first of those is what inferences can be drawn from those types of evidence as to the timing of an occurrence of a case of COVID-19, which can be relevant, for example, in relation to the date of the indemnity period starts to run. And the second remaining point of dispute was the inferences that can be drawn from the statistical data that's available, where the geographical area that's relevant under the insured party's policy isn't squarely on all fours with the geographical area to which, in respect of which data is available. So I won't go into those in more detail at the moment, mindful of time, but suffice it to say for now that the court has said that those issues will need to be dealt with on a case-by-case basis, and so there is a potential for further dispute in relation to those where the value of a particular claim justifies it. But the final point I'll just mention on proof is that I think it's worth noting that the court's penultimate sentence in the judgment was to note that it hopes and expects that insurers will be able to agree on any issues of prevalence that actually arise and are relevant to particular cases, which seems to be something of a call for insurers to take a proportionate and a pragmatic approach to dealing with these issues when it's resolving individual policyholders' claims. So I'll just pass over now to Steph.
Thank you. So to finish up, we're thinking towards the future and what will happen next. I think the biggest question everyone has at the moment is there going to be an appeal? The insurers who have commented so far haven't shown their cards as to whether or not they intend to appeal, but have said that they're considering their options, which I think is what we expect would happen, and it will probably take some time to do so. One point on appeal, because the FCA was the claimant in the case, it's a question of whether or not a party or someone who wasn't a party to the judgment can appeal, so whether or not people will be petitioning either the FCA or insurers who were parties to the case to take it forward if they themselves were not a party and have an interest in seeing an appeal go forward. So the FCA has issued a statement very much in line with what the judgment says, which is encouraging quite quick action, and I think it's partially to get some certainty in the industry as well, where they've said that insurers should communicate with policyholders within 7 days of the judgment, so quite a tight turnaround time there. One thing worth mentioning as well is there is, of course, the Ombudsman regime. So that's, for those who don't know, a free and independent, unbiased consideration of complaints. There's a couple of key considerations to factor in if you were considering the Ombudsman, which is the award limit, which is around £355,000 depending on a point in time, so a point in time of when the complaint arises and is given to the Ombudsman, and also that you only have 6 months from when you receive a final response from the business to which you would be complaining about to go through the Ombudsman complaint process as well. And one other point to note, which will arise from this judgment as well, is that there may be more sort of consequential actions that would arise. For instance, those people who obtained their insurance policy through a broker and perhaps were not given advice as to the type of coverage that is now responding to COVID-19 and whether or not there are professional negligence claims to be considered there as well. And Simon, I think we have some questions that have come in.
We do. Thanks, Stephanie, Emily and Jeffrey for the presentations. We do have a number of questions. Just for the audience, we've received a couple of questions which are very specific to their own policies and which would entail us giving advice, which we're not going to do in the seminar. There's some broader questions that people have also asked. So I think for the purposes of this presentation, we will address those. I think the first, we've got 4, and I think we've got time to deal with all of them. And this one is a critical question on the point of location. And it is, if the occurrence had to happen at the premises for the relevant outbreak or the relevant restriction, and assuming there were symptoms but not proof because there are no tests available, and it's still not provable, how would this be interpreted by the court? Jeffrey, any thoughts before I ask Emily or Stephanie if they've got any?
It's a bit difficult because, of course, if in fact the terms of the clause required the outbreak at the premises to be a proximate cause of the loss, it would be a very rare case where a claim on that policy would succeed on our facts, because, of course, the cause of the loss was the national pandemic and the government's response to it. And it would be, I mean, there may be cases, but not COVID-19 cases, where the presence of an infectious disease on the premises can cause a closure of those premises and loss. But I don't think a policy with that type of term and no wider term, whether it be non-damage denial of access or a radius clause, if neither of those types of cover is available, I don't think there would be cover on our facts where the only cover is the presence of an infectious disease on the premises.
Agreed. Thank you, Jeffrey. I think that's right. We've got a further question, and I'll ask this to Stephanie or Emily at first bite before we pass it on to Jeffrey. Are insurers now obligated to pay where cover exists, even if insurers seek leave to appeal, or can they use the appeal process to delay payment? Emily.
Thanks. I mean, it's a good question, and I think it will be interesting to see how insurers do respond. We've seen, as Steph mentioned, that the FCA has encouraged insurers to pick up with claimants over the next, well, less than 7 days now, 7 days from the date of the judgment. But there is a possibility of appeal, and one interesting consequence that I think will we might see play out if there is an appeal that is brought, but it goes in favour of policyholders. If, for example, the judgment is left undisturbed on a number of the points that we've discussed today, is whether that will affect the position in relation to interest that might be claimable by a policyholder whose claim had not been paid out at this point following this judgment, but has been delayed following until following the resolution of any appeal. So I think it's an interesting question, and difficult to say with certainty, I think, how insurers will respond.
Jeffrey, anything to add on that?
There is no judgment which is in favour of any particular assured. So on one level, you could say there is no legal obligation to pay. It's not like where there is a judgment and the insurer says, well, I'm appealing, where you would say there's an obligation to meet the claim unless there's a stay of execution. But I think certainly from the point of view of interest, Emily is right. I think insurers, if then should at least engage, and some of them might well be wise to admit liability, and then go on to the next stage, which is obviously discussing with the assured's advisors, whether lawyers or loss assessors, the actual quantum, which of course in some businesses may be a very complex matter to actually calculate.
Yeah, I agree. Thank you. And I think possibly the Enterprise Act would also provide some ground for bringing damages claims based on the FCA judgment, i.e. they've had reasonable time. But as Jeffrey noted, if they haven't had a chance to properly adjust the claim, that might not be a runner yet. The next question is from someone I've worked with over the years, formerly head of business interruption unit at Marsh, Caroline Woolley, who asked, with the benefit of hindsight, what should have been done differently in this case? And here I'm assuming Caroline is asking in the context of the case and the procedures of the case, rather than insurers' approach generally, but maybe we can try and discuss both of those.
Would you like me to try and answer, Simon?
Yes, why don't you start on that?
As things stand at the moment, with the judgment we've got, I would say, contrary to what I might have said before the judgment came out, I think it actually worked out very, very well. However, that is on the assumption that the court's judgment on the radius clause, i.e. it makes no difference whether you've got an assured who's got one case of an infectious disease within the 25-mile radius, or an assured who's got 50,000 cases within the 25-mile radius, makes no difference. However, if that judgment, if that assessment of the clause is not upheld on appeal, then and the court says, well, no, it's a much more nuanced, the Court of Appeal says it's a much more nuanced position, which is you've got to show that the presence of COVID-19 within 25-mile area is a proximate cause of the loss, so that there is only cover for those areas where there was a very substantial amount of COVID-19 at the time of lockdown within that 25-mile area, let us say an establishment within central London, then you might have thought that the better way of approaching this case might have been to take some effectively test cases, because the problem in this case was the thing was done without any substratum of fact in relation to particular businesses, and therefore you might have thought that if that's the construction of the clause, that admittedly isn't at the moment, you might have been better to take, for example, as one of your test cases, a particular restaurant in the center of London, and take, and it actually have concrete cases dealing which have concrete assured as test cases with particular policies. Now, as things have turned out, this doesn't matter on the basis of the judgment. But if, for example, the Court of Appeal, it would be the Supreme Court, I think, because I think there is an agreement to leapfrog, or would be an agreement to leapfrog. If the Supreme Court has a different view on the construction of the clause, it might have been better to do it by way of concrete test cases. But my answer at the moment is it's gone very well for the FCA in the way that they have structured it.
Yes, I must agree. I was highly critical of the approach pre the judgment, because I likewise thought it was far too cumbersome and wouldn't support policyholders given the absence of the factual strata underlying it. My view was that it would be a better outcome to have 3 discrete actions by way of sample, disease, wording, and the denial of access and hybrid. I hope I'm proven wrong, but I think we still have to wait to see whether there is going to appeal. Importantly, who appeals? Obviously, it's still open to some policyholders who are disgruntled with some of the outcomes, particularly on the prevention of access issue, as to whether they decide to form a group and appeal. Possibly less likely, but I agree. I think, given the timing, that we should wrap it up there. It just leaves me to thank all our speakers, Jeffrey, Emily, and Stephanie. Thank you very much. This has been a whistle-stop tour of a very dense 162-page judgment, but I think it's a good judgment, and hopefully it will be the benefit of all parties involved. Thank you very much for attending.
Thank you.